Good morning, friends. Today we will discuss another one important topic in GST series, which is denial of your input tax credit for retrospective cancellation of your suppliers. In other words, void ab initio cancellation of your suppliers or post-purchase cancellation of your supplier registration. Whether it is legally tenable, that is the question. So we will take some case studies and how the courts have decided, and I would add some legal point of view also towards this issue. So don't miss this. This is a very important video, and there were a lot of cases and notices were being issued to reverse, or even the attachments were made towards reversal of the input tax credit, which was availed from your supplier who was having the valid registration when the supplies were made. So this is a very important video, friends. Don't miss this. So let us now go into one case law, which is Car Carriers Private Limited, which was before the Honorable Calcutta High Court, wherein the recipient dealer, who was the manufacturer and who do the modifications for the transporting vehicles which transport the automobiles from one place to other place. So he, towards his business, he purchased some MS plates, angles and all, and it was consumed in his business. So it was utilized for furtherance of his business, and he has a valid e-way bill, invoice, and lorry receipts, payment slips, everything, and he made the consideration through banking channel, and on the strength of the invoices he availed the input tax credit. Department has issued a notice to denial of this ITC as well as for reversal of the ITC which is availed on the strength of the invoice. The car carrier private limited approaches the Honorable Calcutta High Court, wherein single judge denied to provide any interim relief, against which this RTP has gone on a appeal before a division bench headed by Justice Sivanyanam and Hiranmai Bhattacharya, wherein after going through all these documents, the Honorable bench come to a conclusion that the input tax credit cannot be denied for the reason that his supplier registration was cancelled with retrospective effect. Because when he was making the purchase, his supplier was having a very valid registration and he was able to create e-way bills, and the consideration was made through the banking channels. But here the supplier, to prove his bona fide, he even made the demand as a advance payment on protest, and he has submitted that DRC3 challans also. Then Honorable High Court directed that to reconsider the issue, and they made a categorical finding that the input tax credit cannot be denied. The second important case from Honorable Madras High Court is Engineering Tool Corporation. The facts are very similar as of which I discussed now. So in this case also, Honorable Madras High Court has held that input tax credit cannot be denied on the sole basis that the supplier registration was cancelled with retrospective effect after the post-purchase. So these are the two important cases. And I said there is one more legal point which you can raise in your defense. That is, as you know, this e-way bills is a statutory document. It was issued in compliance of Section 68 of the GST Act. So it is generated from the e-way bill portal. So it is a statutory document. And you can take aid and support of Section 74 of the Indian Evidence Act, which clearly states what and all public document. Unless otherwise the allegation is that the e-way bill itself is fabricated, you can always take a support and aid in your defense that this e-way bill which was generated and came along with your materials towards your input supply is a public document, because in compliance of Section 68, this is a statutory document which has got created from the e-way bill portal. Unless otherwise the supplier has a valid registration as well as his registration was not cancelled at that point in time when he was making the supply, then only he could have generated the e-way bill. This defense also you could take. I have gone through some of the cases pertaining to this area. So far this defense was not taken. So this is also an additional defense. In future, if you are getting any kind of demand notices or any DRC01 or ASTM10 to reverse on this particular ground, you can take this ground also, because if you have a valid e-way bill, it falls under the category of the public document. In addition to that, what are all the important documents which you need to secure to protect your input tax credit? I will just list down. One is the invoice. The second one is the e-way bill which accompanied the goods in compliance of Section 68 of the GST Act. Third is the lorry receipts. Even though if it is delivery duty paid, in quote terms, there are X works in which you will collect the material with your own transport. If it is DDP, it will be delivery duty paid. So your supplier will deliver the material at your doorstep. Even though that's the case, you try to collect the lorry receipt and you retain with you, and you ensure that you are making the payments through banking channel, and that payments need to be made in 180 days as per the GST Act. And in addition, if there is any payment slips pertain to that particular consignment delivery, you maintain that also. And if you are maintaining any goods inward note or register, kindly try to keep that also. So these are all the documents which you need to protect. Even you try to tag these documents along with your invoice, so that if any dispute comes in future, I think now there are up to 5 years from the date of filing of the final return, GST department can raise any notice under section 74. So you try to maintain this for at least 6 or 7 years, so that if any dispute comes, you can very well show this and you can protect the ITC. Why I am saying this? For an example, if it is a 1 crore transaction and your input is at the tax rate of 28%, the input tax involved in this is 28 lakhs. So for any reason, if it gone on a toss, you will be in a position to lose this complete ITC which you have paid to your supplier for the default of supplier and for want of the document which you supposed to maintain, and you ultimately fail to maintain and fail to produce when any demand or any dispute is being raised by the department. So take care of these things. I will share this writ petition and the judgments also in the comment box for your benefit. You may go through. Thanks. I will come up with some other new updates in future videos. Subscribe my channel and keep focusing on my videos for GST learning. Thank you.